Are you all back?
Yes.
Oh, you were like in such perfect, you all froze. I wasn't sure if it was on. Okay. Like statues. Great. I'm ready if you are, Mr. Zupke.
I'm sorry, say that again.
I said, I'm ready if you are, Mr. Zupke.
Okay, so you want to continue on then?
I do have a few more questions. Yes.
That's fine.
So I want to get into, I guess, this sexual assault a little bit there. There's some things that I'm confused about that. So during the period of the sexual assault, what was the chain of command at that time from the jail administrator up?
Myself as chief deputy, and then the sheriff at the time, McBrennan.
Okay, and you were directly supervising Miss Lavasseur at that time or something else?
Yes.
Okay, then you were the supervisor of the jail or something else?
The entire sheriff's office. I mean, we have deputies, sworn officers, and the jail staff, dispatchers as well. And
this sexual assault, was it ever investigated at any time?
Yes.
Okay, who investigated it?
Detective Zach Pearson is the final one that investigated it.
Okay, what agency is he from?
From the Ashland County Sheriff's Office.
Okay, before him, did anybody else investigate it?
I know the case was given to Ashland PD. It'd be Lieutenant Moreland, who's the investigator there.
When did that happen?
I believe that was in, I think, October 23rd or 28th. I'm around there, 23rd or 28th.
The 23rd is my birthday, so you got my attention. Of what year?
2022.
Okay. And when did the investigation by, what was the name of that deputy again? The Ashland deputy?
Detective Sergeant Zach Pierce.
Okay, and do you supervise him or is it somebody else?
Well, at that time, it would have been me because our lieutenant had retired.
Okay, and how many deputies do you have in Ashland?
We have approximately 21 sworn.
Okay, when did that investigation begin?
Excuse me?
When did the deputy's investigation begin?
I believe he started when he was given it. I think the 29th, he immediately started.
When?
November, I'm sorry, of 2022.
Okay. Now, how were you aware of I guess let's start back up a second. The Ashland Police Department, how did they get involved in this assault investigation?
Like I said, I wasn't notified until that day when Pierce started, but from what I was told, I believe Jail Sergeant Terry Wilbur had requested Ashland PD to investigate it.
Okay, and did he go directly to Ashland PD or something else?
I don't know all the details how that unfolded.
Okay. Do you believe the sheriff at that time did?
I don't know.
Okay. And you never spoke to him about it?
No. I was never notified by anybody of it until the 29th.
Great. And what about Mr. Terry? Did you ever speak to him?
At some point, yes.
Okay. When was that point?
Like I said, around that same day, around the 29th, I was confronted by our domestic violence liaison, Deputy Amy O'Donoghue, asked if I knew about this incident. I told her, she explained it, and I said no. The following day, Sergeant Wilbur confronted me and said, Amy said you didn't know about this. I says, that's correct, I didn't. And he says, well, they requested APD, but they chose not to investigate it.
Okay. And because that's where I'm getting to. Do you know why the Ashland PD chose not to investigate it?
From what I heard, they said they weren't PREA trained.
Okay. Do you know why the Ashland County Sheriff's Department would ask an outside, because you have, just to back up for a second, you have your own investigators, right?
Yes,
Okay, and in fact, you've got the deputy that actually did the investigating is one of those investigators, right?
yes.
Okay, why was he not asked to investigate immediately?
I don't know. I can't answer that. I wasn't involved in any of the situation.
Okay, well, is there a policy or procedure? You're aware of all the policies and procedures, right?
Majority of them, yes.
Okay, is there a policy or procedure that dictates who does the investigation?
No, I mean, like I said, the jail could investigate it. A lot of times the serious offenses, we can have our detectives investigate jail incidents.
Okay, so again, there's no policy or procedure at Ashland for investigating sexual assaults, right?
Well, I mean, we have to follow through on a sexual assault with, yes. I mean, if it's a reported crime incident we're aware of, we have our duty to investigate it.
Okay. So was this, did that fall under that category or something else?
Yes,
Okay, and how do you know that?
it was a victim reported a sexual assault in the jail, and we have to investigate it.
Okay. And now would asking the Ashland Police Department to investigate that, would that be initiating an investigation or something else?
Asking them would be part of the initiating it, but it was never investigated until it was understood.
And do you believe that anybody at the sheriff's department had control over whether the police department investigated the alleged sexual assault?
Like I said, I wasn't involved in any situation.
Well, okay, so
I don't know who was in control of anything during that.
Let's back up for foundational purposes then. Have you at any time been involved in any time when the Ashland County Sheriff's Department asked the Ashland Police Department to investigate?
Yes, we've requested that.
Okay. Why does that happen if you know?
It could be various reasons. Caseload, it could be an officer involved incident, some biased opinions to not include that and have them, or an employee involved incident, can have them investigate the matter.
Okay, and is that what happened here? Is this an employee involved incident or something else?
Well, what happened here is, I mean, I think on both sides that you have you have a victim and an inmate, which we could investigate ourselves, saying he was sexually assaulted in jail on numerous occasions.
So it was right to call ask the Ashland Police Department to investigate, right?
I disagree.
Oh, okay. And why is that?
Because initial investigation should be taking place. If some elements of that comes, say there was a criminal act by an employee, then we would hire an outside agency. But at that time, nobody knew what occurred because it wasn't investigated.
Well, it wasn't investigated because the Ashland Police Department declined to investigate, correct?
By the time they have the case, and a month later when we received it, or November 29th when we received it, nothing had taken place other than
Again, because they refused, the Ashland Police Department declined to investigate, right?
Correct.
Okay. And when did the Ashland County Sheriff's Department receive that information that the police department was declining to investigate?
We said around November 29th, Zach Pierce was requested to investigate the matter.
But obviously the Sheriff's Department was notified before the Sheriff's Department asked its own investigator to investigate, correct?
Yes, it was around that date he was notified. He was requested by Sergeant Wilbur to investigate the matter.
Okay, and who supervises Sergeant Wilbur?
That would be Lieutenant Lavasseur.
Okay. And then who supervises her?
That would be myself
Okay.
At that time.
at that time.
Yeah, I think we're all clear, but yes. Because as of the 3rd, you became the sheriff, right?
Correct.
Okay. Now, without an investigation, how was discipline to be meted out by Kim Lavasseur regarding the sexual assault allegation?
Through my training experience and our supervisor training, as a supervisor, you conduct your initial investigation. When you provide the elements of all the crime, something exists, we investigate the matter. But you should, as a supervisor, you should initiate that, say, okay, initiate your disciplinary if you need be. Granted, there was criminal activity there. The investigator should be involved after you find this out. This was not done.
And do you believe a sexual assault allegation to be an allegation of criminal activity or something else?
Criminal activity.
Okay. And now you know the difference between a sworn law enforcement officer and a correctional officer, right?
Correct.
Okay. And was Kim Lavasseur a sworn law enforcement officer at this time?
Yes.
Okay. And she could arrest people, is that right?
Outside the jail? No.
No. Okay. Was she authorized to carry a gun?
In the jail? No.
No. Okay. So in fact, she's a correctional officer, not a sworn law enforcement officer, right?
She's a sworn employee, but yeah, she's not a law enforcement officer. She's a correctional officer.
Right. Okay. So she can't investigate. If she asked to speak with somebody to investigate, she does not have powers of law enforcement officer to investigate, right?
In the jail, she has powers to investigate criminal activity.
Okay. Now, are there any policies regarding the investigation of criminal activity in the jail?
I can't cite the policy of what it says how to investigate a crime.
Okay.
That's what we do. If we're aware of a crime, we investigate it.
Okay, and that's because there is extremely important here. We, the sworn law enforcement officers, or we, the jail administration?
Correctional officers are all sworn.
Okay, but we're clear that some sheriff's employees have arrest powers and others don't, right?
Yes, if they leave the jail, yes.
Well, even in the jail, you can't arrest somebody, right?
They can book people in, refer charges. They do it all the time to the district attorney's office.
They can refer charges, but they can't arrest anybody, right?
Yes, they can. They can book somebody in the jail for a crime that occurred in the jail and send the charges to the DA. They can be filed.
Okay, I think we've got a different understanding of what arrest powers are, but we'll leave that for another time, I think. Okay. We'll put you on mute for a second. All right. Judge, this is our exhibit, Mr. Examiner, rather, Ashland County Sheriff's Office Sexual Assault Investigations with Detachment.
John.
What's the number on it again?
It says policy 601 at the top, but it doesn't have a number. It has it just says the policies.
That's not it. Actually, there's a preview of making a lot of you. What does it say on your file? It's not Ashland County Jail rules and regulations. It's not chief deputy description. Mission policies, is that it?
Ashland County Sheriff's Office sexual assault investigation with attachments.
Ah. There it is, got it. There we go.
That's it.
And that's gonna be exhibit 4.
Perfect, thank you. Have you seen this document before?
Yes,
Okay, what is this document?
sexual assault investigations,
For Ashland County or something else?
Ashland County.
Okay, and so this would have governed a sexual assault investigations that we're discussing before, correct?
Correct.
What is the sexual assault response team?
It's a team comprised of a group of people that meet quarterly, I believe, or they have meetings and discuss how they respond to the best of their abilities to any sexual assault.
Okay, and part of their duties are to determine who is a qualified investigator, right?
Yeah, it's comprised of multiple people from the area, detectives, investigators, advocates, nurses.
And the policy requires that investigators have certain qualifications before they investigate, right?
You said, can you repeat that again?
Sure. The policy requires that investigators have certain qualifications, right?
Yes.
Okay. And they should have specialized training in and be familiar with interview techniques and the medical and legal issues that are specific to sexual assault investigations, right?
Yes.
Okay. And they should also be present appropriate cases of alleged sexual assault to the prosecutor for review. Did I read that right?
Where are you at?
That's C.
Yep.
Okay.
Yes.
Then it also says conduct follow-up in interviews and investigations. Did I read that right?
Yes.
Okay. Based on your knowledge and experience and supervision of Kim Lavasseur, did she have specialized training and was she familiar with interview techniques and the medical and legal issues that are specific to sexual assault investigations?
No.
No. Okay. And again, that was part of the reason that the Ashland Police Department declined to investigate because they didn't have a PREA investigator, right?
That's what they said. Yes.
Yeah. What does PREA mean?
Basically inmate sexual assaults, how to their response in a jail facility, how to investigate it.
He's asking what the acronym PREA is, which I know is a federal act. We just
Right. Prison Rape Elimination Act, right?
Yep.
And that imposes certain duties on jails. Is that correct?
Yes.
Including the Ashland County Sheriff's jail, right?
Yes.
Okay. And I don't mean to be trite here, but it's a jail that you all have. Is that right?
Excuse me?
The facility that you have to hold prisoners is called a jail?
Yes.
Okay. I appreciate that clarification. Okay. And you knew all about this policy 601 when you decided to demote Ms. Lavasseur, right?
Yes. We're aware of the policies.
Okay. And does Dan Grady, he's also aware of the policies to your knowledge?
I'm unaware if he is.
Okay. Did you and him ever discuss the sexual assault investigation requirements for investigators at any time?
The requirements? No.
No, okay. So, though you were aware that Ms. Lavasseur couldn't conduct these investigations, how exactly was Ms. Lavasseur supposed to issue discipline if she wasn't permitted to conduct these investigations?
Our detective could have been requested to investigate it immediately. Because it wasn't considered PREA from what our detective says.
Okay, so that, and when was that determination made?
When Detective Pierce received the case in November.
Okay, so he
29th.
immediately upon receiving it knew that it wasn't a PREA compliant case, right?
I don't know how he sought his advice. I'm assuming he got it from the district attorney's office.
Okay. So that's fair to say that as at least no earlier than November 29th, the sheriff's department believed that this was a PREA compliant case or something else.
Objection to the classification of that testimony.
Well, if he knows, it's
Yeah.
gone for a legal conclusion. If he knows.
I don't know if they knew that. Like I said, I wasn't involved in anything prior to that date.
Right, but you've investigated this since then, right?
Yes,
Okay, so based on that knowledge, do you know?
yes.
Okay, what's the answer?
As far as the PREA consideration,
Right.
from what our detective said, it's not considered PREA investigation. He couldn't.
Right, but it was considered a PREA investigation by the Ashland Police Department, right?
That's what they said.
Right, okay.
Yes.
Right, so between whenever the date was, which you don't remember, when the Ashland County Sheriff's Department got the, let's say, the information that the Ashland PD declined to investigate, from the time that, because it was PREA, from the time that they started in the Ashland County Sheriff's Department started investigating, the Ashland County Sheriff's Department believed that this was a PREA case, correct?
No, like I said, our detective received investigated it immediately and found out it wasn't considered PREA.
Okay. And then it's also fair to say that it wasn't until the investigator, and let's be clear, was that investigator, did he have specialized training in, and was he familiar with interview techniques and the medical and legal issues that are specific to sexual assault investigation?
Yes.
How do you know that?
We document his trainings. I mean, he goes to, he primarily does our sexual assault, abuse cases.
Okay. And is it your testimony that, and I'm sorry, there was a deputy, and I believe you said his name was Max?
Zach Pierce.
Okay. Was he the only person that was communicating, or sorry, is he the highest level person that was communicating with the police department over this investigation?
Is when he received it, upon him receiving it?
No. The question is Max, first of all, let's start with Max. And again, I didn't hear his last name.
Zach Pierce, Detective Sergeant.
Okay. No, that's not who I'm talking about. Who, if you know, sent the request from the sheriff's department to the police department to investigate?
I wasn't involved in any of that. I was told after the fact it was Sergeant Terry Wilbur of the jail that requested them.
I appreciate that. Sergeant Terry Wilbur. Okay. And so again, based on that investigation, do you know if there was anybody higher than Mr. Wilbur who was aware of the investigation being sent to the police department?
I'm unaware. I wasn't not involved in anything at that time.
Right. And we've established that, and I appreciate that. But you've also testified that you've investigated this incident, right?
Our detective investigated.
Right. And then you got the benefits of his investigation, correct?
I'm sorry, can you repeat that?
You have then reviewed his investigation, right?
I have not reviewed his investigation. He updated me summarize the situation.
Okay. So that's your only understanding of the investigation and what happened here? Or do you have other sources as well?
From Detective Pierce, what happened with that incident? Like I said, he summarized me. He showed me the brief video of the actual altercation of the sexual assault. That was it.
Okay. And excuse me, but I want to be clear, that's the entire sources of information you have about this incident, correct?
I believe so.
Okay. Now, and this is something that's very confusing to me. You said that you watched a video and that you observed in this video that there was a sexual assault, right?
Correct.
Okay. But you've also told us that the sergeant detective determined that there was no, it was not a PREA issue, right?
Well, like I said, he's familiarized with the requirements of be considered that. Doesn't mean there wasn't a sexual assault that occurred in the jail.
But sure. But correct me if I'm wrong in your explanation, but the highest sworn law enforcement officer at the sheriff's department has just testified that he watched the video and according to his determination, there was a sexual assault, correct?
It appeared to be, yes.
Okay. Do you believe sexual assaults to be PREA issues or something else?
The requirements for PREA I can't cite off what the requirements are right now, but like I said, the detective spoke with a legal representation. It wasn't considered to be needed to be PREA or trained him to be trained in it. That's what Ashland PD said. They were not trained in it.
Okay. But again, I just want to be clear, right? That your testimony is that you observed the sexual assault taking place in the jail and that you don't believe that that made the investigation required to follow PREA guidelines, right?
Correct. That's what I was told.
Okay. And so you're, I understand. Okay. I got it.
I've got a question just for clarification, and maybe this will prompt some more questions. Is there a difference between an investigation for PREA compliance and an investigation for a sexual assault, if you know?
I can't cite the difference right now.
Do you know if there's a difference?
Our detective told me there's a difference. From what I was told, he weren't required to be trained in PREA to investigate the matter.
All right, sir, that exhibit that you have, if you can go down, it says with attachments. So this is the penultimate page there, the second to last, if you will.
So this would be page 5 of 6.
That sounds right to me. It is a picture of an email.
Looks like the email says forward PREA investigation. You see that?
Yes.
Good.
Okay. And do you see your name anywhere on that email?
Yes,
Okay. And do you see Ms. Lavasseur's name on that email?
yes.
Okay. Who's Scott Moreland?
He'll be a lieutenant investigator.
With what agency, if you know?
He was the Ashland Police Department.
Okay. And again, November 15th, that's before November 29th, right?
We can look at the calendar to see that.
All
Yes.
right. Great. So I'll just read this out. Kim, I had spoken to Mel, who requested an email why we were not handling the request to do the PREA investigation. I had first asked for Mel and Terry W. for your policy on outside agencies doing PREA investigation. Moments later, I had spoken with Hagstrom. Do you know who Hagstrom is?
He's the chief of Ashland Police Department.
Okay. Who was aware of this incident? Did I read all that right?
Yes,
Okay. And then it said I had originally handed off this case for Shard to investigate. Who is Shard, if you know?
he's another investigator for Ashland Police Department.
Shard was requested to speak with ADA Kressel. Do you see that?
Yes,
Okay. Who stated that investigator has to be specially trained under the PREA statutes to do these investigations. Did I read that part right?
yes.
Okay. And is this the same ADA, if you know, who later supposedly told you that the investigation did not have to be done according to PREA statutes?
I don't know who our detective spoke with. Which one? There's three.
Okay, but you didn't ask him?
No,
No. Okay. Okay. But again, at that time when you were told that by your investigator that he had spoke with this unknown assistant district attorney, that you knew that this ADA Kessel stated that the investigator had to be specifically trained in PREA, right?
I mean, based on this email, that's what it says. Yeah.
Okay.
This email, I don't even know what they're talking about because it doesn't say anything.
I don't know what that means, sir. Can you explain that to me?
I don't even know what investigation they're talking about in this email. At the time I got it, I was unaware what investigation was taking place.
Okay. At this time on November 15th, what steps did you take to determine what the purpose of this email was?
I didn't take any steps. I didn't
Why
know
not?
what. I wasn't included in anything at that point in time.
Okay, except you were included on this email, correct?
Correct.
Okay. Now, let's again talk about, and I guess we covered this briefly here, but when you were supposedly told by this deputy that this wasn't a PREA compliant investigation, what steps did you take to investigate what the subject of this email was?
So our detective took the steps of investigating the matter, and he's not PREA trained. He had sought advice that he didn't need to be.
Okay, so it's fair to say that no one in the Ashland Police Department nor the Sheriff's Department was PREA trained at that time. Is that right?
Correct.
Okay, and although the policy required somebody who was PREA trained to investigate these investigations, right?
No.
Okay, and again, this is the investigation on the criminal sexual assault that you have identified, right?
Correct.
Okay, now, how many as of November 15th, how many investigations were going on in tandem with the, how many PREA investigations were going on in tandem with the Ashland County Sheriff's Department and the Ashland Police Department?
How many were going on?
Sure.
I'm unaware of that.
Okay. Isn't it true that this is the only one?
Like I said, I'm unaware. I mean, this is the one I'm aware of now of the investigation.
Okay. So again, it's your testimony that you weren't aware of this investigation that you were copied on as early as November 15th of 2022, right?
No, because it cites nothing about any investigation name or incident number, anything.
Right. And how many, and again, You're not aware of any other PREA investigations that are ongoing at that time, right?
No,
No. Okay. And you did nothing to follow up on this email, right?
no,
No. Okay. Well, except for then ultimately you demoted Kim Lavasseur, right?
yes.
Okay. Now, I don't know that we were totally clear on this, but until an investigation happened that was PREA, or that, at least that your determination that because you had no PREA investigative officer in the county to do the investigation, that you were not going to investigate it as a PREA compliant matter, how was Kim Lavasseur supposed to issue discipline until an investigation happened?
Like I said earlier, they can investigate matters in the jail. They're all pre-trained in the jail.
Okay. So again, but that conflicts with your earlier testimony that there was no PREA trained investigator for the in the county, right?
You said investigator, detective. I'm taking it literal as you're referring to our detectives.
Okay.
Said the jailers are PREA trained.
Are they PREA trained in how to do investigations or something else?
But they can start any initial investigation to find out what's happening. Like I said earlier, if it's severe enough where we need a detective involved, we'll do that.
I appreciate that. Can you answer my question?
Are they PREA trained? Yes. Jailers.
PREA investigations.
As far as training investigating, no.
No. Okay. And that was what was required versus on the policy, right?
On the policy, yes, but the PREA training itself helps them identify a PREA incident.
Great, which then is
Technically, they're trained in
investigated
that.
by a PREA trained investigator, correct?
An investigator, yes.
Okay. Now, thank you for that. I hopefully this can be our last round here. I understand that there is a policy that requires a report to be written on the sexual assault allegation, right?
Yes.
Was that report ever written?
By Detective Pierce?
By any person?
Yes, he had written a report after his investigation.
Okay, how about before the investigation? Was there any report?
I'm unaware of any report before the investigation.
Okay, but you have access to all the reports?
Yes.
Okay, and in fact, you're the, as chief deputy, you were the supervisor for
Yes.
the jail?
Yes.
Okay. All right, just 1 second, please. All right. So I am done with questions for this witness at this time. I do have an issue, Mr. Examiner, that I would like to discuss here now.
Okay.
And that is, I guess, our motion in limine to prevent the county from presenting any of its witnesses or exhibits. As I'm sure you're aware, the hearing procedures, that's Rule D3, requires the employee and the county to exchange a list of witnesses that they intend to call at a hearing and any documents and exhibits they intend to introduce at the hearing no less than 5 calendar days before the hearing. That did not happen in this case. Mr. Lindsay sent us a recording, I thought extremely abusively, at the night, on Monday night. Naturally I'm in hearings all this week, and I didn't get any of these documents until quite later. Now, luckily for us, prejudice is not the standard. Here is the standard, and there's a very strict rule here, and I'm sure it's been applied to employees many times, but now it needs to be applied to the county. No witness, exhibit, or document which was not identified or exchanged by a party may be introduced in the hearing absent a written finding by the impartial hearing officer that there was good cause for the failure of the party to timely identify a witness or produce a document. So we submit based on those rules, you have no jurisdiction because we don't have any absent a written finding ahead of time here that the county therefore is prevented from calling any witnesses or using any of the exhibits identified in its list because it failed to follow the rule, which required it to exchange those with us as a matter of fairness here. We also want to point out again that this is a mandatory rule. There is no discretion here. Again, no witness, exhibit, or document which was not identified or exchanged, and we're saying it wasn't exchanged, within the 5 business days, because Monday is clearly not 5 days before now, that and without a written finding by the impartial hearing officer that there was good cause for the failure, that documents or witnesses may not be introduced. So to that extent, we argue here that Mr. Lindsay has no more than 10 minutes for this witness because he can only cross-examine witnesses here today. He has no power to call or introduce any call witnesses or introduce documents because he failed to exchange them according to the rules, which then deprives you of jurisdiction over hearing those documents. So that's where that stands right now. Again, had they followed the rules, they wouldn't be in this position. But of course, it's not fair to my client here to have been sandbagged in the first place. It was really outrageous, I think, to bring this document at 9 o'clock on Monday, really 2 business days before the hearing. It's just outrageous, but not surprising, I guess I'll have to say. But ultimately, it doesn't matter because the rules are quite clear and explicit. Again, I want to just mention briefly that I've seen a lot of these grievance procedures, and never have I seen a grievance procedure that was so one-sidedly in favor of the employer and so manifestly opposed to the employee having really anything but the bare minimum of due process rights here. This is one of these examples of those rules. Unfortunately, it works both ways. Mr. Lindsay couldn't get his act together in time. He failed to write. I guess if he had seen that paragraph, he would also know about the pretrial, pre-hearing statement. He failed to do that as well. That's between him and his client.
Right,
failures.
Stop.
I get that, but nevertheless, this needs to be excluded.
Stop. Do you have a copy of that policy, agreement policy?
I have it in
Hold on.
Sorry.
Stop. Do you have a copy of that in front of you?
I do.
Can you go to 1.06 calculation of time?
Sure. What was the letter, please?
1.06. It's at the very bottom.
Okay.
54 of whatever policy this is. Take a look at that. Take a look at that and see if, in light of 1.06, you're.
Calculations of time. When the last day for taking any action, the grievance falls on the day when the county courthouse is closed. The action may be taken on the next day the county courthouse is open. Okay.
So today is day, I guess, the hearing day. So going back Wednesday, Tuesday, Monday, so it would have been Saturday, right?
No. You can try to turn 3 days into 5, but you can't. Because that would have meant that they would have had to file it ahead of time. The business days there is what let's say, defeats that.
Where's
so if it had
so that's up in
other than business days.
Hold on, stop. Where's the business days? What section is that?
This is in D procedures. This is on page 49. 5 calendar days. Sorry, no, it says within 5 calendar days of the date of the appointment. Calendar days. So again, if the only thing that would get you to do is if you're filing a deadline to going forward, okay? So if the date was starting from someday in May and we're going forward, for example, May 1st, and the deadline is on the 5th, and then from there we calculated the deadline, the 5th is a Saturday, okay, the courthouse is closed, it's due on Monday. We're not tracking days after, we're tracking days before. So either way, that gets you even further. And he should have filed them by, again, within 5 calendar days of the date of the appointment of the impartial hearing officer.
Okay, 5 calendar days. I'm looking at the calendar. 5 calendar days from the 13th going back is April 8th, which is a Saturday. And
yeah, you know what's not 5 calendar days? That would have meant that it was due before. It's not the Wednesday, Monday is not 5 calendar days from Thursday. Okay, so that does not turn, it does absolutely does not turn the 10th into a calendar day. So if they want, I can easily.
I don't like this policy, I'll be quite frank, but I'm bound by it. It says calendar days, and under 1.06, when the last day of taking action, which would have been Saturday, falls on a Saturday, the action may be taken the next day the county courthouse is open, which is Monday. I don't like that, but that's what it says.
So again, the issue isn't the calendar days ahead from there, because that would only give us 3 days notice. And that's not what that rule says. So that would make a mockery of that rule of the hearing date. And we can just go look to how dates are calculated. When the last day of taking any action proceeds on the day when the county courthouse is closed, the action may be taken on the next day the courthouse is open. That does not give us 5 calendar days to respond, and turns that into 3 calendar days to respond. That's not what that means.
I don't think you get a chance to respond. Again, I'll note your objection, but technically I think it's in compliance with the policy. Whether or not the policy complies with the due process muster, that's not something that I get to decide. I know your objection, I understand it, but I think it technically complies.
Okay. Right, so then we go to calendar days. And again, even if you do that, then we submit that 9 o'clock is absolutely too late for that. And that calendar days does not fall within any time that night.
I think it goes until midnight.
It absolutely does not.
All right, I note your objection. I will overrule it. I'd like to finish up Mr. Zupke's testimony here. Hopefully we can get that done before noon. We can get this thing moving.
All right. So, Mr. Zupke, there was a lot of discussions and back and forth and issues that you were asked about. I'd like you just to explain in your words what led to the decision to terminate Ms. Lavasseur.
What led to me is, I believe, myself and Ashland County overextended herself by saying, we'll still offer you a job. During that meeting, as a job as correctional officer, during that meeting, I said I wasn't told about any of this investigation from a couple of months in limbo. It wasn't investigated. Being the chief deputy, I wasn't involved. You know, how many days till my first conversation with her, January 10th, she finally brings up to me that this happened. Well, during that meeting, she basically said, told me I was aware of it. I have a poor memory. She said, Terry Wilbur told you. I said, Terry Wilbur told me after he found out, I found out November 29th, not in October when I should have been notified. She basically, like I said, became excited about it, started getting a little louder with me saying I knew about it. At that point in time, I said, I'm not going to argue with you. The meeting was ended. I wasn't happy with it because I said I wanted to keep her on as an employee. We left, she was escorted out, and I determined, like I said, the next day that she was be terminated.
And was there more than just this specific communication about this one investigation?
Yes.
And what other issues?
So in October, I believe it was like around 28th, we had a couple employees, jailers that were wanted to quit. As far as I know, an email was sent by one of the female jailers. She said that basically she couldn't operate like this anymore. She had prior experience in Bayfield County Jail, I believe, as a supervisor. And she said the inmates controlled the jail. Basically, it was out of control. This is not how she wants to operate. She was later chosen, I believe, a private meeting with her and Lavasseur and the then Sheriff McBrennan. They convinced her to stay. After they convinced her to stay, that jailer requested a private meeting with me. I met with her, and she disclosed the same thing. She says that there is no control in that jail. Lavasseur wasn't involved. I asked if she spoke with Lavasseur and worked this out to make it a better jail. She says, yes, I've tried multiple times. She does not listen to me or anyone. Like I said, and there was another male jailer, that the other jailer that quit as well. He had several meetings with me prior. I don't know exact dates, but basically said the same thing. We're going to have several people that aren't quit here because of their lack of involvement. She was always hours at a time, multiple hours throughout the day. She'd be sitting on the administration side of the building, which is the other side of the building is separate from the jail. She'd be sitting there, non-related stuff, having coffee all day. And they wanted her to be involved, some kind of leadership. And this male jailer warned me that several people would quit. Like I said, he did quit. I wasn't involved in that meeting as well with Lavasseur and Brennan. I'm not sure what was said in those meetings, why, but I know prior to hand, I had several meetings with him. Him explaining this distrust with her as a leader and as a jail lieutenant.
And when you mention lack of control of inmates, what type of actions or activities were referenced or have you been aware of that were occurring in the jail?
From what I knew at the time, I mean, it was common to, on a daily basis, there would be blankets or uniforms hung up in front of a cell. Inmates would be in there, not knowing what they were doing. I mean, there's two violations right there. Like I said earlier, basically the rule violation is if it's not your cell, you shouldn't be in there. And because, there's two bunk cells, but if the difference is it's not your cell, you're not allowed in there. And then you can't hang any items in the jail because you don't know what's going on.
And excuse me, and Detective Pierce's investigation into this sexual assault allegation, in reviewing those records, did you find that those rule violations were common in the jail?
Yes.
And were those rule violations corrected or enforced, those rules enforced by any jail employee or staff that you could see?
No.
In your conversation or your answers to Attorney Hitchcock Cross's questions, you had mentioned some question of why no discipline was issued relating to this issue or this incident.
Yes.
And was that discipline you were referred to for the act of sexual assault or for these other rule violations?
For the rule violations, I mean, like I said, from what Detective Pierce told me, I mean, there's active jailers would be walking through, observing these and not doing anything about it on a daily basis.
And from your knowledge, let's say in the second half of 2022, were any jail employees ever disciplined for failing to require compliance with the jail rules?
For the jail rules, no. I mean, there was some write-ups, I believe, maybe one or two, but by Lavasseur that basically in that second half that they didn't explain anything. You know, on numerous occasions when she'd write people up when she was first jail lieutenant, I said, you need to give a narrative, emails, proof of what happened. And it was always they didn't follow rules, or the jailer didn't follow rules. I says, you can't write people up without an explanation. You need to say why, who, what, where, when, and why. And she failed to do this. So if there was a write-up during those times, like I said, it was bare minimum. They weren't listening or whatever.
Okay. And during the time that Lieutenant Lavasseur was serving as jail administrator, did you experience or witness any improvements in compliance with these jail rules?
No.
And how long was Lieutenant Lavasseur the jail administrator?
I believe, I'm not sure, that it was maybe approximately close to a year. I'm not sure.
And since Miss Lavasseur is no longer serving as a jail administrator, have you witnessed improvements in compliance with these jail rules?
Tremendously. As far as employees, inmates complying, it was immediately adjusted. There was basically, it was enacted by the interim that there was zero tolerance for any of this. I'd say within 2 weeks' time, inmates were abiding by orders. The atmosphere is so positive in the jail. All the employees are excited that there is leadership skills in there, and every day they're there helping and assisting with a team effort.
You had mentioned Ms. Lavasseur's, well, strike that. Can you explain, while Ms. Lavasseur was the jail administrator, what you witnessed as her ordinary daily or weekly routine while working?
It was usually, like I said, in the mornings. I think she started off, I don't know if she was there early enough, it'd be in Sergeant Wilbur's office, which is kind of near the front lobby for extended amount of time. Then you usually would come over to the detective's office, and could be an hour or two there, and then wander over to our administrative secretary, confidential secretary's desk. And she'd go back and forth throughout the day, but it was always coming back and over, having coffee or talking with everybody. I mean, it could go a couple, 2, 3, 4 hours, 5 hours someday. There out of an 8-hour day that, well, it's spent on the opposite side of the building.
Okay. And had you ever discussed with Ms. Lavasseur this routine that she had of spending time on the administrative side of the building?
Yes, I did. So at some point after, when the female jailer attempted to quit and she stayed, I had the meeting. Lavasseur did ask how the meeting go. I told her good, but she came. I did give her advice. I says, Kim, you have to be involved over there. You sit over here quite too much. You need to be involved. They want you over there to help. There's a lot going on getting in the jail cells. I mean, I recommend. I gave her, example of me. I hear calls on the street where they need help with the officers. I'll respond. I have my radio. I'm listening. They respect that. I kind of reiterated that to her. I also told the sheriff at the time, McBrennan, the same thing, and other private conversation with him. My concerns with her always being on the administration side, not doing work-related stuff. He says, he agreed with me. He goes, I told her the same thing, that you and I go on calls on the streets. She needs to be involved, get in the trenches with her workers, get respect and show leadership.
After you, after you had the conversation.
Just object. I mean, to the extent that that's hearsay, I understand hearsay is allowed, but I'm still going to object.
There's a lot of it hearsay that's been going on here. I'll give it the weight it's worth, but I understand.
Following that conversation with Lieutenant Lavasseur, did you witness any improvement in her performance as a jail administrator?
Usually, if I suspected things that weren't going well over there, that improvement would last maybe like a week, and then it'd go back to what it was, which was decreased, and went back to You know, the original behavior of the rules not being followed.
Couple clarifications on county policies or hiring policies and procedures. Ms. Lavasseur, as a jail administrator, was, I think we clarified this, but she was not a law enforcement officer, correct?
No.
And she was just serving in a county administrative position.
Yes.
So although the sheriff and the sheriff's office has oversight over that position, she is just a regular county employee,
Yes.
right? Okay. And as being a regular county employee, the county administrator actually has ultimate authority to hire and fire. Is that your understanding?
Yes.
Okay. And prior to Ms. Lavasseur's termination, you had discussed with Dan Grady the option of terminating Ms. Lavasseur.
Yes.
And you gave him your opinion that she should be either terminated or demoted.
Yes.
And Dan Grady agreed with your
Yes.
opinion. Okay. So that was not your unilateral decision and action then.
No, it was my decision.
And Dan Grady, the county administrator, went with your decision. Is what you're
Yes.
saying. Okay. When Ms. Lavasseur was terminated as jail administrator on January 19th, was she ever rehired as a correction officer?
No.
Was she ever rehired in any capacity?
No.
So when she was removed and terminated as jail administrator, that was the end of her employment with Ashland County?
Yes.
Regarding your communications with Ms. Lavasseur and looking into the investigation into this sexual assault incident,
Yes.
what were your main concerns with that investigation?
Well, my main concerns is basically when they receive that written statement from the victim and the inmate victim, that it wasn't immediately looked into and should have been immediately done within that day. Start an investigation. There was no, as an employer, like I said, it's your job to immediately look into the matter, make sure it's investigated, find out, okay, this did happen. Now what do we do? Like I said, if a jailer, one of our jailers or anybody that's pre-trained, like, okay, now we need to get an outside investigator or detective, or detective, which we have. It should have been handled immediately. The video would have shown immediately, okay, these guys from immediate booking within a day or two, they're in the cell together. They weren't in an assigned cell. One of them wasn't assigned that cell, and they're in there every day for those 2 months. And nothing was done at any level whatsoever.
And based upon your review of Detective Pierce's investigation, was the allegation of sexual assault between these inmates first raised to the jail around September 27th, 2022? Does that sound accurate?
Yeah, I believe.
Mm-hmm. And in your review of this investigation report, after September 27th, 2022, were these two inmates continued to allowed to be in the same cell together?
From what I was told by the detective, it did continue, I believe. I'm not sure the amount of days, but a week or two.
Mm-hmm. And were items continued to be hung up in these inmates' cells, blocking the view while they were in there together?
Yes.
And so after September 27th, 2022, do you know how long it was until Ms. Lavasseur referred this investigation to an outside entity?
I believe it was October 28th, Ashland PD was requested.
So that was over a month from the first allegation of
Correct.
sexual assault. During that time, did the investigation reveal that any biological specimens or DNA specimens were taken from any of the individuals?
From what I was told through Detective Pierce, some of the uniforms were taken from the victim that might have had some DNA on there from the suspect.
But correct me if I'm wrong, but that didn't occur until approximately November 11th, right?
I didn't review Pierce's report. If it says that, I mean, I wouldn't know what exact day that was, but
Is it safe to say that didn't occur immediately upon the allegation?
from what he told me, yes.
In your opinion, after reviewing this investigation and being aware of these allegations of sexual assault, would the conduct, strike that. When did you first speak with Lieutenant Miss Lavasseur about this sexual assault investigation?
January 10th,
So it was before she was terminated?
yes.
And what did you discuss with her in that conversation?
She came to my office and advised me. She goes, Detective Sergeant Zach Pierce to conclude his investigation. And my words to her, this is the first time you've informed me of this investigation. She says, I thought you were told this, I believe, by Wilbur. I says, yes, he did tell me after I found out through Amy O'Donoghue on November 29th. But that was how much longer after this was reported. I says, you know, if you had told me immediately, we could have handled this incident appropriately like it should have been. And we wouldn't have been in this situation. And we talked about the high probability of a lawsuit, and she agreed.
Did that conversation, to the best of your recollection, involve your issues with the lack of discipline and required adherence to jail rules?
Correct.
Yeah, it did.
Well, like it was minimal. Like I said, I just said, you know, it wasn't investigated. You didn't tell me, and I said you didn't include me. I didn't go in detail of, you know, what she should have done. It was minimal. She acknowledged it and said, I thought you knew, Terry told you or whatever.
And 1 second. During the meeting that you had with Ms. Lavasseur on January 19th, after she was terminated as jail administrator, did you discuss the lack of requirements, the lack of requiring inmates to adhere to jail rules?
Yes, I did.
And do you recall what specifically you told Lieutenant Lavasseur about that issue?
Basically, I said they were in these jail cells together. You know, inmates weren't supposed to be in there together. The sheets. She said, I believe she told me she had talked to the jailers. I says, well, where's the discipline? I mean, obviously, this was more of a severe event that was failed to follow through on some of these jail rules. She said, I talked to him. I said, well, where's the documentation of any of this, that this occurred? She didn't have any. I said, it was never given to me. It would have to come through me. I was never notified of any of it. But yes, this was brought up.
Okay. And did you ask her why these individuals were continued to allowed to be in the same cell together?
What I remember, I believe, I don't remember the entire conversation, but I believe it was said something along the line, this happens all the time. I mean, there was no response of this was wrong, you know, at all.
In either this conversation on January 19th or January 10th, did Ms. Lavasseur indicate to you in any way that she thought she had responsibility to ensure these rule compliances?
Not once.
What did she indicate to you, whose responsibility she thought this was?
What she indicated to me is she goes, basically, I believe she told the sheriff that the jailers, you know, they were ones weren't abiding by enforcing these rules. And that was her only admission of anything.
And as sheriff, do you and will you rely on your jail administrator to run the jail according to the jail rules and policies?
Yes.
And could you have trust in a jail administrator who deferred responsibility for enforcing those rules?
No.
In your opinion, was the manner that the jail was operated while Kim Lavasseur was the jail administrator potentially dangerous to inmates or staff?
Correct. Extremely.
And can you explain why and how?
We said that just the lack of supervision as a supervisor, you know, being involved, enforcing all these rules from the jailers. Like I said, I mean, when you're sitting on the other side, not leading by example, and then it got to the point where the employees just didn't care anymore, whether they weren't properly trained, failure to have somebody confide in and help as a leader. It just got dangerous because when the employees and staff break down, it turned into chaos where the inmates are running the jail. And it could be an inmate outbreak of attacking a jailer, or it could just be like what we encountered, the sexual assault. I mean, there's sometimes there's accidents that happen in jail that you can't prevent. But at the end of the day, when you have plain blatant rule violations that aren't being acknowledged, that it's a cause for disaster.
Okay. And that meeting on January 19th, you recorded that meeting?
Yes.
And I'm going to pull up that recording. Or John, you could.
Well, yeah, I think if you grab access.
Yep. Or I can just play it through the.
No, because then they can't hear it. So you need to, hold on. You need to request permission, right? Make co-host. Okay, so then you should be able to share screen, and I think it will play it over that. So hold on, though, that's going to be.
So Judge, I guess I forgot about this. So now, given, although we have conflicting testimony here of when the actual decision was made to terminate and who is the decision maker, the latest testimony from this one witness is that Ms. Lavasseur was terminated prior to this meeting. So therefore, there can't be any discipline at issue in this meeting because she was already terminated. and therefore this meeting can't be the subject of the grievance based on his testimony that she was already terminated. Therefore, it's irrelevant.
All right. First, I'm going to mark it as Exhibit 5. And then the meeting on the 19th, that's what this recording is?
Yes.
And Attorney Hitchcock Cross's objection is that it's irrelevant because she was not terminated at this meeting. And the grievance is on the termination, not the demotion. Is that?
No, I'm sorry. So, because we've had conflicting testimony from this witness, but again, the last thing that he said was that she was terminated prior to this meeting and never rehired. So if that's the case, and now he's saying, because he testified earlier when I asked him that she was employed until the next day, but now again, he just testified that he terminated her ahead of time. So based on that statement, again, there's confliction, but okay, then if she's no longer employed by the county when she gets this letter from Mr. Lindsay, then she can't possibly be disciplined at the recorded meeting. So therefore, because again, I mean, that's clear, that's the appeals court is very clear, you can't be disciplined if you're no longer employed there.
I understand. And I think there's been a little bit of an issue with the sheriff's testimony regarding him terminating Ms. Lavasseur when technically she's a county employee. It gets into a gray area with a constitutional officer terminating. I've dealt with that in other cases, but technically I don't think he can terminate her as a county employee. That ends up coming to the county administrator.
I hope you're not assuming facts, not in evidence, Judge, because that's definitely not in against the rules of this grievance procedure here. But again, we've had two conflicting statements from this witness, so that's part of what the problem is.
There's been a few conflicting statements beyond that. I get that. Okay?
Right. So he said at one point that he was the sole decision maker. He said on prompting from Mr. Lindsay, he said no, he did it in consultation with Mr. Grady, but then he repeated that he was the sole decision maker. But again, whoever is the decision maker, now the testimony is that this decision was made, I mean, obviously prior to the letter that Mr. Lindsay handed to her on the 19th. So if she's terminated as of the moment that she gets handed the letter, then no discipline can occur after that point. Therefore, the meeting itself is not the subject of the discipline here at issue here. Again, if you're going to accept the latest theory that they put forth, and that's what makes it irrelevant. Because again, if she wasn't employed after that, before that meeting, then what occurred after the meeting cannot be disciplined.
And I'll respond. It is relevant. Ms. Lavasseur's grievance specifically states, I have no knowledge of why I was terminated. The recording of this meeting clearly shows she was explained all the issues that led to her termination. Okay,
I've noted the objection. I'm going to overrule it. And the reason I'm going to overrule it is that I think technically the termination, I think it was in the one letter that I did review prior to the hearing here, which was the county's response. And maybe this is wrong. The testimony will hear it out, but
well, can I voir dire on that subject?
Who are you going to voir dire?
The witness here. Because that's the key issue, I guess, that, and you know, I understand there's been conflicting testimony, but if she was terminated and that's her position, that's their position, then again, this isn't discipline. So we got to get clear on that fact before we can be clear about what relevance this document may or may not have. We don't otherwise dispute it. Again, it's just for the purposes of, you know, being efficient here. This is the new theory, again, really truncates this hearing, because if the only discipline that was meted out, again, it's a moving target, but let's assume that it is, then there can't be discipline because she was terminated by that letter.
Well, looking at the grievance form, we've got all sorts of dates here. So we have, as agreed to with Corporation Counsel Max Lindsay, the grievance date is 14 days from January 27th letter. Haven't seen that letter. The grievance filing deadline is February 10th. Then it also says, I have no knowledge of why I was terminated on January 19th. So when was she terminated?
I will.
Go ahead.
Yes. Ms. Lavasseur was terminated on January 19th. She was terminated as jail administrator. That's what I had just questioned Sheriff Zupke about. She was not rehired as a correctional officer. That offer was made. She was not rehired, so she was still terminated as jail administrator. January 27th was when she received that final notice that she was not being rehired. So the termination date, it's in the documents everywhere that are here. It's in the emails that Ms. Lavasseur has marked as exhibits, was January 19th.
Okay.
So it sounds like we need to examine Mr. Lindsay next, if he's going to be giving evidence here. So we're ready for that. We're ready for that.
All right, knock it off. I'm gonna.
Not even a little bit, Judge. You're not going to talk to me like that even for a second. He just testified. No, I'm not going to stop. He just testified.
No, you are going to stop because you're not in control of the hearing.
Okay, but I also have due process rights and I need to get my objection on the record. I'm not going to be told to knock it off.
You can try that again, but you're not going to overtalk me.
Right, I was talking and then you told me to knock it off.
Stop. I'm going to overrule your objection. We're going to allow the recording. After we get done with this witness, you can call your next witness. If it's Mr. Lindsay, so be it.
Fantastic.
All right, play the recording. I will add that I do have a number of questions in between when Mr. Lindsay is done and when you're going to be asking, I'm assuming, more questions of Mr. Zupke here.
I understand. Thank you.
Good.
Go ahead. Can you hear this? Can you hear the recording?
No.
No.
That's not. Okay, so you're gonna need to take your microphone and put it down to your speaker.
Mm-hmm.
And then see if that works.
And Your Honor, really, if there's no objection to the admission of this recording, I would just admit this recording as an exhibit and it speaks for itself.
I don't have any objection to that.
I'm sorry?
I have no objection to the introduction, putting that in the record.
Fine.
I mean, again, our objection that it's irrelevant, notwithstanding the, if he doesn't need to put it before this witness, that's perfectly fine. I note that it's difficult to hear in parts, and it can best be listened with speakers, for example, which is what I had to do.
Fair enough.
When I first heard it this morning.
Okay, continue on.
All right, and that was exhibit 5?
Correct.
Okay, and then here's something just to confirm here. In that meeting, in that recording, you explained to Ms. Lavasseur why she was being terminated as a jail administrator.
Yeah, I explained the reason for the demotion. Okay. Basically that she was, for the failure to act on this investigation and notifying anybody, myself, I mean, all the violations that occurred. And there was an immediate investigation with 2 months of sexual assaults that were happening.
Okay. That's all here.
Okay. Questions that I've got. If we assume that your first date of knowledge of this incident was November 29th, you indicated the first time you spoke to Ms. Lavasseur regarding the sexual assault was on January 10th?
Correct.
Why was there 40-some days in between that time?
So it was, in my opinion, like I said, there was private meetings that I'm unaware of, do not know what was said between the sheriff and at the time, Jail Lieutenant Lavasseur. Based on, they didn't want this to be knowledgeable to me. I felt like this was being covered up in my eyes. I felt if I initiated anything during the time while the sheriff was in office, McBrennan, that it could destruct evidence. I wanted to wait till he was gone because it wasn't a very good setting as far as how I was being treated, being the sheriff-elect, and I was kept out in the entire time of this incident. I felt there would be more destruction of evidence if I initiated anything while Sheriff McBrennan was there.
Until you took office on the 3rd, you were Ms. Lavasseur's direct supervisor, right?
Yes.
So in that capacity, you didn't think that this was serious enough to discuss with her?
During that time, like I said, I wanted the detective to conclude his investigation. And when he concluded, we were going to approach her.
Mr. Carlson, just so we're clear, I'm having trouble hearing your questions.
Understood. So my question to him.
I think we got it, but just going forward, please.
Sure, I'll speak up into the microphone. You indicated that there's been additional write-ups in the jail since the interim administrator has taken over. Is that correct?
I'm confused. I don't remember saying that. Write-ups for
Rule violations?
No, when I mentioned earlier, I believe, if I remember correctly, that it was about she had written up a few people during her, like I said, this latter half of her when she was hired as a jail lieutenant. There might have been a couple that she had wrote up, but there wasn't usually there wasn't a good explanation why. Just said they weren't following rules. When I said that earlier, Kim Lavasseur, there may be some write-ups.
Okay. You indicated that she would spend 2 to 3 hours in Sergeant Wilbur's office.
Well, throughout the, like I said, the building's cut in half. His office is kind of in the front lobby, separate from our administration side. She'd go over there for however long. It varied throughout the day. Usually, I would say a good hour every day. Or then come on the admin side, talk to the detectives, the secretary, the sheriff, and all of us, whatnot, throughout the day. It could vary a couple hours, 3 hours, 4 hours. I mean, it depends.
What would she be doing during this time in Sergeant Wilbur's office?
I don't know.
Is it performing her job?
I'm unaware.
Is part of her job entail being in his office for some purpose?
It could be. I know our current interim jail administrator doesn't practice that procedure. He's on his side most of the time. Does he go over there once in a while to have a meeting with him? Yes. But it doesn't entail the amount of hours that used to be spent on our side of the building.
You're copied on an email dated November 15th. If you recall that, I believe it's Exhibit 4.
Mm-hmm.
It's in this packet right here, last page, or second to last page.
Mm-hmm.
Right?
Yes.
So that would be probably the first time you had knowledge of a PREA investigation going on in your jail?
That's what I knew of, a PREA investigation.
But you didn't know exactly what it was for 2 more weeks?
No.
Did you make any effort to inquire?
Like I said earlier, the atmosphere wasn't very good at the time. I wasn't included in anything. I was secluded to not being involved. It was strictly a relationship between Lavasseur and the sheriff. Usually if I asked too much, I would get deterred by the sheriff. So it was kind of.
So while you were her direct supervisor, you were not in a position to inquire such things as whether or not there was a sexual assault in the jail? I'm just trying
Could
to
I,
understand
I mean,
this.
could I? Yes, but like you said, the relationship that existed or was assumed the sheriff and Lavasseur had that relationship, like he was in direct control of her. Like she's admitted already in the past that she reported him.
I have no other questions. Mr. Hitchcock,
Great.
Ross, you want to?
Thank you, and I'll be as brief as I possibly can. So did I understand you, Mr. Zupke, that you would just accuse the prior sheriff of destroying evidence related to the sexual assault allegation?
I didn't accuse him at all. I says I was the fact that I wasn't involved. I just said I was worried that if I exposed anything while he was in term, that either I would be harassed or there could be evidence that could be missing or whatnot. I mean, the fact that I wasn't involved speaks for itself.
Okay. And again, after you were copied on November 15th, right?
Correct. I mean,
Okay.
it has no explanation of who it is or what it is.
Okay. So then let's just also be clear. You explained to us before that you had instructed Ms. Lavasseur to write more detailed write-ups, right?
Yes.
What was the purpose of writing more detailed write-ups?
To explain who, what, where, when, why, what it is, you know, why she's doing it, what violation was occurred, explain it in general instead of just saying they're not following orders.
Okay, and that's for policy, right?
Yeah, I mean, it didn't ask for an explanation on the form. So what did they do?
Okay, and that's so that the county follows the law, right?
The county what?
Follows the law.
Yeah, I guess, like I said, there's usually if you write somebody up, you have that explanation.
Great. Okay, but you didn't follow that here, right?
Did follow what here?
You didn't give an explanation
Yes, I
prior
did.
to imposing discipline, did you?
The day she came in my office, I explained to her why that occurred on
Okay.
January 19th.
And that's again, that was after, right?
Correct.
Okay. Then have you read the grievance response form?
Briefly, I'd have to have it in front of me.
Is everything in there true?
I'd have to look at it.
You want to make that an exhibit?
Sure. Thank you.
This is going to be 6. Let's see if she'll find it here. You can go ahead.
Okay. Is everything in that statement true?
Yes.
Okay. Thank you. Do you have any relation to Kyle Kadat?
He's my wife's cousin.
Okay. And what sex is Kyle Kadat, if you know?
Excuse me?
What sex is he? Is he male or female or something else?
Male.
Okay. Does he identify with any particular race that you know
of? Native American.
of? Okay. And how do you identify with a particular race?
Native American Hispanic.
Okay. Do you know Miss Lavasseur's age?
I can say approximately around 50. I don't know her exact age.
Okay, and how about Mr.
50.
Kadat? I'm sorry, I don't mean to cut you off.
I'm guessing around 50.
Okay, and how about Mr. Kadat?
Again, I believe he's around 35.
Okay. I guess my final question to you is here now, is it your testimony that you made the decision to terminate Ms. Lavasseur or somebody else did?
I made a decision, like I said, to terminate her that day, and it called up our corporate counsel and advised them and the administrator that this is what I wanted to do.
Okay. And you have, because we've heard some testimony that there's two kinds of employees. There's sworn law enforcement employees, and there's regular county employees who also work for the sheriff department. Is that true?
Well, the difference between we have a union, deputies are in a union that have a different set of rules, and then the rest are not in a union are considered all county employees.
Okay, and who's the appointing authority for all the people in the sheriff's department?
The sheriff's
An
office.
objection to that, to the extent it calls for a legal conclusion.
Okay, have you fired anybody other than Kim Lavasseur?
Since I've been in office, no.
No. Have you received any training and terminations?
I've went to several supervision trainings.
Okay, based on that understanding, do you know whether or not you're the decision maker to terminate Kim Lavasseur or something else?
I couldn't hear what you're saying. Say again.
I said, based on that training, do you know whether or not you're the decision maker to terminate Kim Lavasseur or something else?
I still don't hear that. What's the last word you said?
Or something else, right?
Oh,
Did you?
okay. Okay. Well, like I said, I mean, I don't know the rule on that, but I wanted to terminate her. I called the corporate counsel and administrator and says, I want to terminate her. I advised them to send a letter.
Right, and that person was Max Lindsay, right?
Yes.
Thank you very much. I have no more questions for this witness at this time.
Mr. Lindsay.
Oh, just one briefly. In looking at that email on November 15th, that is part of Exhibit 4, that you were CC'd on. That email came from Scott Moreland of the Ashland, City of Ashland Police Department.
Correct.
The objection, the calls for facts, not an evidence. As I understand it from that document, he was sent that, not copied on it.
Okay, that you were included in. That came from Scott Moreland, correct?
Yes.
And nothing was ever sent to you from anyone at the jail or from anyone at the jail regarding this?
No.
Okay, nothing further.
Okay, anything else? Otherwise, I believe Mr. Zupke is free to go.
Yeah, and when I said not at this time, I have no further questions for you. Thank you.
Thank you.
Thanks, Brian.
Next witness.
Max Lindsay, please.
All right, and I'm going to object to that on several grounds. First, the grounds that Mr. Hitchcock-Cross so adamantly argued earlier regarding timely notice of witnesses and exhibit lists. We were provided with an amended witness list on Wednesday, the day before the hearing, that added me as a witness. Even if that is, I honestly don't care about the timeliness of that. But notwithstanding that, I would object to being called as a witness on the ground of privileged communication, and to the extent that Mr. Hitchcock-Cross has shown no reason why I would need to be called as a witness. If the hearing officer is considering allowing me to be called as a witness, I would request an offer of proof from Attorney Hitchcock-Cross as to what he expects me to testify to that could not be obtained by some other witness or some other source of evidence.
Oh, very good. I'd be happy to do that. So as far as I understand that you had participated in a conversation with the complainant when you handed her these letters, and that you also participated in further communications with the complainant post-termination, and that you participated in communications with her, I guess in regards to, yeah, I think you had understood you had a meeting with her that was scheduled for January 30th, in which you gave her the final or second termination notice. So those, I understand that there are going to be some things that you will know that are going to be privileged. And to that extent, I won't ask you for those. And if I do inadvertently, then it would be absolutely proper not to respond. But to the extent that you are a primary witness of and involved yourself directly in this termination, again, and up to and including having conversations with nobody else that was not recorded with the grievance, which were witnessed by nobody else, that in itself makes you a necessary witness there. So again, and then just to be clear for the analysis for anybody else who has to review this, a witness or all parties in Wisconsin are entitled to all persons' evidence unless there is a privilege. That privilege are to be narrowly construed to the extent that it exists and balanced against the needs of persons who have interest in having evidence. So again, here, I don't know that there's a privilege at all. There certainly is not a privilege with respect to his communications with Ms. Lavasseur. If there is a privilege, it would extend to any legal advice that he may or may not have gave to county employees, but I don't intend to ask him about those kind of questions.
And to the extent that that is the basis for it, I would say I am not a necessary witness. Ms. Lavasseur can testify as to the substance of any of those communications.
Well, okay, so first, I don't know what the relevance is going to be, but that would just pan itself out. But very unusual to call an attorney as a witness. I guess the question I have is, what specific to this grievance are you asking Mr. Lindsay to testify to?
What, if anything, he said to her during when he handed her this document?
And why wouldn't you ask your client to testify to that? I know you can call him to do that, but why are we doing it this way?
I think he's got the best evidence. I'd rather have his testimony as to what he said as opposed to hearsay. So we do have that's the best evidence. First of all, and second of all, you know, the fact that he's attorney doesn't shield him here. It's the fact that he participated in these. You know, he could have had somebody else participate in handing her the documents. It didn't have to be him, but once he did it, that made him a necessary witness. He could have recorded it. He didn't do that. There could have been some other way to memorialize this information. We don't have that. So to the extent, and he's obviously now read Gonzalez Villa Real, and I commend him on that, but he's clear now on the standard of that he's a necessary witness. Again, Miss Lavasseur would be hearsay as to what he would say.
And if I may on that offer, or my requested offer of proof, what do you expect me to testify to? And the county would likely stipulate that that was the case.
You're going to stipulate to what you said? Because that sounds like testimony.
Well,
stipulate the facts to be
so
proved.
here's where so obviously Attorney Lindsay handed her a letter. I think it's dated January 19th. I don't have it in front of me. Obviously he did that. I guess the question is, was there any further oral conversation with Ms. Lavasseur when he handed her that letter?
That's my understanding, yes, and that's what I wish to inquire.
Are you saying that there was a conversation?
Yes, I'm saying that there was a conversation.
Well, what are you saying was conversed? Can we just stipulate to it? Move this whole thing along?
I mean, I appreciate the thing for, as I understand, there was some discussion about what was said. I hate to be in the role of testifying here, and I'm feeling uncomfortably being placed in that role. But I understand that there was some discussion about what she had done wrong and what he was aware of what she had done wrong. So that's exactly germane to this issue here about what was communicated to her prior to this meeting with the sheriff and whether or not there was actually any notice or not.
Okay,
so that's why it's such crucial and vital information here and extremely relevant because it all goes back to when the decision was made, who made it, was it reasonable?
Well, I don't think you can get into that, but I will allow you to ask him whether or not he told her why she was being fired and or terminated. I guess that on the 19th, that was a demotion initially. And if he says, yes, we had some, I told her why, well, then you can ask him what those reasons were. But if
Sounds good, thank you.
If he says no, then I'm going to cut you off at that point.
Great. Can we place him under oath, please?
Raise your right hand. Swear to tell the truth, the whole truth, and nothing but the truth. So help you God.
Yes.
All right, Mr. Lindsay, do you know Kim Lavasseur?
Hold on. Set a record. What's your name?
Max Lindsay.
Please state your last name.
Lindsey.
All right, go forward.
Okay. And do you have any connection with Ashland County?
Yes, I am the corporation counsel.
Okay. And do you know Kim Lavasseur?
Yes.
Okay. How do you know Kim Lavasseur?
She was the jail administrator at Ashland County.
Okay. And did you participate, I put another way, did you hand deliver any documents to Kim Lavasseur at any time in January of 2023?
Yes.
Okay. Was it more than once?
On which date? I'm sorry.
Anytime in January. Did you hand her documents more than once?
I provided her with documents.
Okay, what is provided?
On more than one occasion, yes. I know one was hand delivered. I don't specifically recall if the second was hand delivered or emailed.
Okay. And the first document that you handed to her, what was that document?
The January 19th letter that's been admitted into evidence.
Okay. And I've got it. January 19th of 2023, and it says regarding Ashland County Notice of Employment Action, right?
Yes.
Okay. That document also says you may continue your employment with Ashland County in the position of corrections officer in the Ashland County Jail, right?
That's what it says, yes.
And it also says, please meet with Sheriff Zupke as soon as possible today to return those items and discuss your employment status, right? Continued employment status, right?
Yes.
Okay. When you handed this letter to Miss Lavasseur, did you have any communications with her at that time?
Yes.
Okay. What were those communications?
I advised her what the letter said, that she was being removed and terminated as jail administrator, and to follow up and speak with Sheriff Zupke as to the reasons and any discussions about continued employment.
And you used the term terminated?
I don't specifically recall.
Okay. But you did before, right?
I don't understand your question. Before when?
You recall that you used the word terminated in the previous answer, but you don't recall that now. Is that true?
Yes, I used that term in my answer. I don't specifically recall what word I used when I handed Miss Lavasseur this letter on January 19th.
Okay. Did you draft this letter to somebody else?
I did.
Okay. So when you explained to her the meaning of the letter, that was based on your knowledge and understanding of the letter as you drafted it, or something else?
I never testified that I explained to her the meaning of the letter, sir.
Okay. Well, then maybe I misunderstood. Did she ask you what the letter meant?
I don't recall.
Okay. Did she ask you if she had done anything wrong?
I don't believe so, but I don't specifically recall.
Okay. And then I want you to point you to this second paragraph in this letter. It says, please meet with Sheriff Zupke as soon as possible today to return these items and discuss your continued employment status. Do you see that?
Yes.
Okay. And that meeting with Sheriff Zupke, that was prearranged between you and Mr. Zupke, right?
Yes.
Okay. But you didn't tell, do you see here where it says the purpose of this meeting?
Yes, to discuss your continued employment status.
Okay, thank you. And then was there any other time in which you, I guess, gave or communicated a employment status to Kim Lavasseur?
I met with her at one other time to give her the information on the grievance procedure.
Okay, and I just back up for 1 second. This document says enclosure. Do you see that? I'm sorry, you may not have this document in front of me. Okay, you do. Was there an enclosure to this document?
Yes, that was the county's grievance procedure.
I got it. Okay, and then you see how it says copied, CC, carbon copy?
Yes,
Did you copy those individuals?
yes,
Okay. And how would you have copied them?
email.
Email. Okay, and was this done prior or after giving this letter to Kim Lavasseur?
I don't specifically recall.
Okay. And would those letters have been provided to Ms. Lavasseur by public record?
I don't understand your question.
Okay, your emails to Mr. Grady and Mr. Zupke copying them on this employment letter, was that given to Ms. Lavasseur during public records?
I'm gonna cut you off because I don't care.
Okay, I appreciate that. Let me go to this
get where
next.
you're going if there's an open records violation, but it doesn't matter here.
All right,
I
I
get what you're
appreciate that. Now, if I can just direct your attention to the second letter here on January 27th. Do you have that?
All right, that's gonna be a new exhibit, right?
It is a new exhibit here. And it's in our section, it's 230127, letter from Lindsay to Lavasseur -- termination.
Okay, that's gonna be exhibit 7.
Did you see that letter?
Yes,
Okay, did you draft that letter?
yes,
And did you give it to Miss Lavasseur?
yes, I provided her with a copy of it. I don't specifically recall if it was personally delivered or mailed or emailed.
Okay, but were you out of the office sometime prior to January 30th of 2023?
Yes,
Okay. And so it's in fact you met with her on January 30th, is that right?
I believe so, yes.
Okay, and this is in person?
Yes, at my office.
Okay. And that's on 6th Avenue, right?
Yes,
Okay, so let's just go to this document here. It says, in my capacity as Corporation Counsel for Ashland County, this letter is in follow-up to my January 19th, 2023 letter and our meeting in that day, and in response to your meeting with Sheriff Zupke. Did I read that right?
yes, you did.
Okay, it says the county has decided to immediately terminate your employment. Do you see that?
Yes,
Who made that decision, if you know?
that was. And I would state that that is a privileged, well, I'll answer, that's fine. As Sheriff Zupke had previously testified to, he did after discussing and in coordination with Administrator Grady.
Okay. So based on your understanding at the time of this letter here on the 27th, was Miss Lavasseur still employed by the, I guess let me put it another way, when did Miss Lavasseur's employment with the county end?
As I stated previously, January 19th.
Okay.
Kind of going beyond what I think we were going to limit the scope here on as to what conversations Mr. Lindsay was going to have or had with Ms. Lavasseur.
Okay, and I appreciate that feedback, Judge. I will rein it back in. I've got one just question here, and if that's too much, please let me know. So did you have any conversation with Ms. Lavasseur when you met with her in your office?
Yes, there were conversations.
Okay, what were those conversations?
I don't specifically recall what was said. If your question is if I discussed the reason for her termination, the answer is no, if that's what you're getting at.
Okay, can you answer my question though?
Yes, and I did. I don't specifically recall.
Okay, then just to clarify, you don't specifically recall, but you do recall that you didn't discuss termination, is that right?
I did not discuss the reason.
You did not, okay, and how do you know that?
Because I instructed her to file the grievance in the documents that I had given her, and the county would respond and answer any questions that she had.
Okay, and is that the time in which, because I think we've had some statement here by the examiner that on this grievance form, there's mention of a conversation with Max Lindsay about the date of the grievance deadline. Are you aware of that?
Yes.
Okay, did you discuss that with Ms. Lavasseur at that time?
Yes, that is when I advised her when the grievance would have to be filed.
Okay, and again, how, if she was terminated on the 19th, how is it that the deadline for filing the grievance started on the 27th or some other date?
I offered Ms. Lavasseur the courtesy to have additional time to file this grievance because I was out of town and not able to meet with her.
Okay. And I guess I want to be clear, if you know here, the date of this letter says January 27th, 2023, right?
Yes.
Okay. And although you were out of the office until January 30th of 2023, right?
I don't specifically recall when I returned.
Okay, no problem. So, Judge, if we can just turn to 230123, email from Lavasseur to Lindsay.
And I'll stipulate, yes, my automatic reply said I was out of the office until January 30th.
Perfect.
I do not specifically recall when I actually returned.
Okay, do you have any reason to believe that you're that you met with her prior to January 30th?
No.
No, okay. So can you explain why the date of the letter is January 27th?
That was when it was sent in to her.
By mail or some other way?
I already said I don't specifically recall.
Okay, do you have any evidence of how this was sent to her?
There's her mailbox on there, and I assume it was mailed. I also did personally hand deliver it to her on the 30th when we met.
Great, okay.
Let's keep it moving here. Let's keep it moving.
I think we're done here, Judge. I appreciate it. And sir, just so you know, wherever you're standing, however you're standing right now, it was very difficult for me to hear what you were saying. Mr. Carlson, just.
All right, hold on. I guess gotta move this microphone. It's buried behind another. I don't like this setup.
I mean, I totally understand. I can't react to the feedback if I don't.
Fair enough. But
okay.
The troubles of doing my Zoom, but that's fine. While I'm talking here, though, there was I think a reference to an email that had an auto reply that you have. Is that going to be an exhibit or no?
He stipulated to it, so I mean,
right. So what number?
The fact that he handed it to on the 30th is the only reason for that exhibit. So if that fact is stipulated to, I don't think we need it as an exhibit.
Do you have that email? Lavasseur to Lindsay?
Sure do.
I'm just trying to find it here. There's a lot of emails.
It's right. So this email it's right above below the one email from Grady to Kadat and Zubke. So in the section, the numbered section there, it should be 1, 2, 3, 4, 5, 6 up from the bottom, which I guess isn't that helpful.
Okay.
230123. It's the last one of that date.
What's the file name that you have it on?
Email from Lavasseur to Lindsay.
Okay, I found it. Okay, so that is 230131, and I'm gonna mark that as exhibit 7, I believe.
Great.
Okay. I'm sorry, that's 8.
Okay.
Any other questions?
No, thank you, Judge.
Well, it's noon. You want to take I'd like to keep charging through lunch, to be honest, because we're seemingly not too far into this, given the number of witnesses that are on the list. Do you want to take a 5-minute break or 10-minute break and then continue on?
Sure.
Yes.
Is Mr. Grady available next? Do we want to do the sheriff next or the previous sheriff?
I can have Mr. Grady available in 10 minutes.
Let's do it.
That. Let's do that. We'll take a 10-minute
break. Can we have 15, Judge? I mean, I understand, but I got to eat.
That's fine. Fair enough.
We're not all.
Use the opportunity to go to Quick Trip and get some more coffee. So let's do 15 minutes.
I'll spare you my city mouse joke. Appreciate it, Judge. Thank you.
Let's leave this recording.
You want to? We can pause it also. Okay.